Well, good afternoon, ladies and gentlemen. My name is Ross Melzer, and welcome to this breakout session, which is called Who Owns It? The Problem of IP in Publicly Funded Projects. Now, this issue of how to handle IP in a public sector, open innovation context is, of course, politically important. We've heard this morning in our three parallel sessions, Open Innovation, Open Science, and Open to the World, that it's not easy to navigate this kind of problem. And it's in the very nature of collaborative research and innovation projects that different partners with varying mindsets and interests come to sit at one table. And against this backdrop, obviously, properly managing and protecting your knowledge and know-how should be an integral part of the overall management of your project. And if it's not, then you won't be able to disclose your knowledge and ideas safely. You won't be able to prove ownership. You certainly won't be able to profit fully from commercial exploitation. And you won't be able to prevent or discourage its unauthorized use by others. So before we dive into this issue, let me introduce our panel this afternoon. Representing policy making from the Commission, we have Bart Janse, who is a legal officer in the Common Legal Support Service at DG Research and Innovation. To his right, we have Gabriele Moosler, who is the Vice President for Patent Development at Ericsson. Moving along the line, we have Rick Henschel, who is a partner at the US law firm Foley and Lardner. Then we have Raymond Hegarty, who is Managing Director, Ivy International Licensing at Intellectual Ventures. And last but not least, we have Brian Graves, who is the Director of Business Development at Imperial Innovations. Welcome to you all. I'd like to start by asking Bart at the Commission for a brief overview, three to 4 minutes if you can, to begin with, Bart, and there'll be plenty of opportunities to come back to you, of how IP, according to the Commission, should be handled in a publicly funded project. And you can talk about before the project starts, during the grant preparation and project implementation, or at the project end, or a combination of all three. But how should it be handled?
Well, first of all, as you rightly indicate, the importance of IP in a multi-partner project, especially one that is based on technology, that should not be underestimated. Good IP arrangements between the partners, in particular if they take account of the various interests of those partners. They allow for the necessary trust for partners to really cooperate and not just work separate from each other. And also they provide some assurances, at least, that the project as proposed can actually be implemented and the results, hopefully later, can be exploited. Now, the legal framework, you have to start with the rules for participation. In those rules, basic rules are laid down regarding ownership, access rights, obligations to exploit, obligations to disseminate. However, these basic rules leave a lot of room for flexibility, i.e. for additional rules specific to a project need. To ensure that people think about these additional rules, there is a requirement in most cases for consortia to have what we call a consortium agreement, which is a private agreement only by the members, so not signed by the European Commission, in which they lay down these type of additional rules. Now, this can be rules relating to financial issues, but also relating to IP issues. To help the participants, we have what we call the Consortium Agreement Checklist. It's a guidance published by the Commission in which we detail what type of issues they can foresee in their consortium agreement. Among the IP issues mentioned are, for example, is there a need to foresee rules regarding joint ownership? Or is there a need to foresee additional access rights, meaning licenses given to third parties who perhaps work in the project or to exploit later the results of the project? That's where we, as a Commission, we stop. We do not provide model consortium agreements because we don't want to. Because otherwise people may just take the models and take them literally, and even though they may not exactly be adapted to their own specific project. One size fits all does not really work in this respect. However, other people have, on the basis of the guidance, on the basis of the rules in the Model Grant Agreement, have developed model consortium agreements. They have not been reviewed, nor they will have been endorsed by the Commission, but they can be used if people are aware that they should adapt them, the models, if they don't exactly suit the needs of their specific project. Finally, to come to a good IP arrangement, of course, you need to have some IP awareness and knowledge about the type of issues that may come up in a research and innovation project. To help the least experienced players, for example SMEs, the Commission funds a project which is called the IPR Help Desk, and the task of that project is to provide first-line advice, IPR advice, that can be general IPR advice, but also specific to IP issues encountered in research and innovation programs such as Horizon 2020. However, even with all that, feedback we get from participants is that negotiations around these IP issues remain a difficult item.
Okay, so you mentioned this IPR help desk, and they produced this very useful guide, your guide to IP in Horizon 2020. So what exactly is the purpose of this if you're not laying down distinct guidelines? You're just helping participants to avoid pitfalls? What will they find in here?
Well, what they find in there is basically an overview of the basic rules which apply, and where are the opportunities for flexibility, what type of issues they should be thinking about, and foreseeing perhaps in their consortium agreement the necessary provisions to deal with this type of situations.
Okay, that's great for setting the scene, thank you. So that's the theory. What I'd like to do now is be very practical and to turn to each of the panelists and just ask you to begin with for one example where you know there has been an IP issue or conflict amongst project members in a publicly funded project and how it was resolved. And even better would be if you could add how it could have been avoided in the first place. So, Gabriela, one example, please.
Yeah, I'll start with one example, which maybe is very typical for big companies. Like big companies typically consist of several affiliated companies, but one company is member in such a project. But for us, it's important for the specific big ones that also the affiliates have the access rights to IPRs, to the others which are created in there. And this is a typical conflict we have specifically when these consortia agreements are done with other companies which don't have this affiliate structure. How it's solved, I think it's solved by negotiations, explanations, and also saying that as a big company, you need to have this structure allowing, because one company is the partner, the affiliate needs to have the access rights. Of course, if you're a smaller company, university or so on, you feel, is this fair? But I think the explanation and going through, that's how it's solved.
Okay. Rick, you come at this from a very interesting perspective. Most of your experience is obviously in the US, but I also know that you've advised clients in France. If you know, with your one example, I don't mind whether it's a US example, European, up to you.
Well, I'm a US patent lawyer, and one thing I'd want to emphasize right away is that you have to think internationally because patents only protect you in the country where they're issued. So the IPR help desk guidelines are actually very good. How many of you actually read those before coming here? I see just a few hands. Well, my advice to all of you is before the end of the week, try to read through the guidelines once as a start to getting some experience and understanding about the issues that arise. You're not going to absorb it all right away, but this is extremely important because so many problems that I see flow from just almost a complete lack of understanding of issues that arise. So any little bit of knowledge and understanding you get by reading these documents would be helpful. Here's an example of a problem, and they come up very, very often, typically flowing from inventorship, because under US law, and I think here as well, the patent rights go to the inventor. And then from there, the inventor typically assigns rights to the employer. Well, in this case, our client had begun working in a collaboration with a research institute in the United States. The client happened to be in Germany. And the research institute was simply meant to implement the ideas of the inventors in a very routine fashion to show that proof of concept, nothing more, no inventive contribution. Well, one of the researchers at this US institution just came up with an idea and said, oh, why don't we use this technology, which was a diagnostic, a gene diagnostic for a particular disease. I'm not going to mention any names or even the technology because I'm not authorized to. But in any event, the US researcher came up with the idea of perhaps using it in a particular therapeutic context, which to some of us seemed relatively obvious, not particularly patentable, but it ended up being in one of the claims. Now, no one noticed this at the time, and when the cases were transferred over to us, we took a look at the portfolio and we saw this and realized, well, wait a second. That claim now brings ownership to that U.S. entity. Why? Because under U.S. law, an interest in a single claim or inventorship of a single claim brings with it ownership of the entire patent. And unlike what I understand is the case here, under U.S. law, if you're a co-owner, you have no responsibility to the other co-owner, and you can license or sell your share without getting any approval and without any accountability. No financial compensation of any kind is necessary. I believe in Europe that might be different. So you need to be aware of that. But in any event, our client didn't like that situation. And there were some problems with the assignments that were drafted as well. So what we decided to do was to split the patent in two, so that the claims that were exclusively due to the inventors that worked for our client would be in one patent, and the other claim would be in another one. And in that way, we were moving towards resolving the situation, although it ended up being a bit more complicated because, as I mentioned before, there are international ramifications, and it turned out to be much more difficult to do this in some of the other countries where we had filed applications. So this is an example of the kind of trouble you can get into.
Okay, Raymond.
I have a similar example from the past in an Irish situation where an Irish university had come up with a very interesting technology, and I was asked as an IP strategist to come in and advise about the commercialization of this and where it fits in. They were looking at the potential value of this technology and this business somewhere between 10 million and 30 million, and they were really trying to get me to assess where it came on that scale of between 10 million and 30 million. When we dug into it a little bit more, though, we found that one part of the development of this technology was done in conjunction with Intel. Intel had loaned a researcher and the equivalent of about 5,000 euro in support to this project. And in exchange for that, they were told that they would get access to this technology. Now, the application that Intel would use it for was very limited compared to the total potential applications of this technology. But when we looked into it, we had found that they hadn't nailed down the exact terms of this, and that, in principle, Intel not only would be able to practice it themselves, but they would have the rights to sub-license to anybody they wanted. So this was a hole in the exclusivity and the ownership of this patent that the university inventors denied that this was a limitation, but it went from a valuation of between 10 and 30 million to a valuation of 0, because there was a backdoor and that they couldn't have claim entire ownership of it themselves. This is something that if they'd got proper legal advice in advance about how to set up this relationship, they could have foreseen this eventuality.
Yes, I'm beginning to see a thread here of proper, good legal advice up front. Brian?
Yeah, I would agree about the question of advice. And the other thing is that when you're dealing with commercial partners, that there are some industries that are much more familiar with intellectual property and licensing than others. And so this question of competence applies both to the industrial parties as well as to academic and university parties, and to a certain extent regardless of size as well. So for example, in the pharmaceutical industry, intellectual property management is a very key part of the business model and is very high levels of competency there. I think another issue is with universities and the complexity of knowing where to go in a university if you're an industrial party, because you'll find that there are research contracts teams and then you've got the technology transfer teams that are involved with the management of intellectual property. And these sorts of contracts span the two. So from the university side, dealing with these things in a joined-up way is a challenge within the university. It's also a challenge, I think, for companies trying to deal with universities, knowing where that they should, who they're actually dealing with. But it also applies that a lot of companies themselves, even big companies, are not necessarily as well advised and competent around intellectual property.
So what does Imperial do as a university that others don't in that respect?
Well, we keep the technology transfer organisation is separate from the research contracts group, but we have a very strong working relationship between the two of them. And I think another theme that comes out of this is that contracts are built on trust, and the words are there to cover eventualities, but it's all about building trust, and it's about building the conversations between the different groups. And so we have a strong working relationship with our research contracts group, and if there are non-standard terms, then they will come and talk to us. And we also have a legal team that's very experienced in intellectual property law and management. So we're fortunate to have a lot of those competencies in-house.
Before I go back to Bart on that, let me turn to the audience. Are there any initial reactions, or do you have your own stories or examples that you'd like to share with us at this stage? Anybody? Not quite yet. Yes, we've got a microphone, please.
I just have a question about the intellectual property being of the inventor, and the inventor is the researcher. I thought that in the university, when there's research going on and there's an invention following that the institution, the university, is the owner, and that they have to give a good compensation to the researcher. But that's all.
That's a good point, but I think that reflects a slight lack of understanding of the legal framework. First of all, you have to have an agreement in place, and it'll vary from country to country. Certainly here in Europe, you know, I have to say the IP landscape is a bit of a mess, to say the least. And I know we're looking forward to the Unified Patent Court, the unitary patent, but even that to me seems a little bit less than crystal clear. But an agreement does have to be in place, and it depends on what the agreement is. Now, I'd just like to point out one thing that you should be cautious of, at least in terms of U.S. rights. There was a case that decided some years ago that if you sign an agreement as an employer that uses the language, I hereby assign rights to inventions and intellectual property and patents, patents in particular, that document causes the immediate transfer of ownership to, in this case, let's say the university, as soon as you carry out the invention. If you simply have a promise to assign, which is the more common language that was used before this case, then that needs to be followed by a formal written assignment to carry out the transfer. And that actually created a problem in some cases. So this is the type of thing that just about any good U.S. patent attorney would include that language in an assignment. But it's a situation where it makes sense for you, if it's your invention, to read the assignment before you sign it. Are there any inventors here? Are there anyone here who's got a patent or two? Well, I can tell you that did you read the assignment word by word, line by line? Good for you. That's utilitarian, of course, probably why you're the president of the university, because you're that careful. But most people are not, especially if it's in a foreign language. But it's a situation where you'd want to make sure, or at least confer very closely with your patent attorney, who would probably advise you along these lines.
Okay, so
I can maybe add
Gabriele,
one thing.
yes.
I think it's in Europe mostly like this, that universities, depending on the country and employment contracts, own it. But if there is a US patent, it's still important that the right inventors are mentioned. If there's an inventor missing, the whole patent could go abandoned, irrespective of the assignment and so on. So that is, I think, what one has to pay attention to, and which is also the problem in collaboration. When groups sit together and invent, to make sure that the right inventors are mentioned. And if they're coming from two different companies, institutes, 3, 4, 5 companies, that's the crucial point, because that could cause a patent, not only in the US, also in other countries, to go bust or ban.
Okay, I'll come back to Bart in a second about this concept of joint ownership. But Brian, you had a comment first.
Yes, just there were two parts to the question. One was about the ownership, and the other was about the rewards policy. And every university will have its own policies around how inventors are rewarded. And that can also create some conflicts, particularly if you've got multiple universities with different rewards policies. That's another, as it were, commercial aspect, particularly for the university side of it, that adds another layer of complexity to an already complex situation.
Okay. So, Bart, no doubt you're aware of many of these issues, not the first time that you would have heard them, I'm sure, but given the collaborative nature of most projects, some results will be jointly developed by several participants. And in these cases of joint ownership, I guess that potential conflict is inevitable or not?
Well, maybe first to come back, indeed, many of the examples sound familiar, and in particular, if U.S. law or U.S. participant is involved, it becomes even more complex, because clearly the law is not exactly the same. First to invent, first to file. Also the fact that most of the time, as my colleague said, in Europe, there is an assignment of the rights to the beneficiary. Actually, our rules say that the results are owned by the beneficiary, and the beneficiary is, in most cases, the legal entity on which the research team belongs. And under the grant agreement, the beneficiary has the obligations to ensure that it has all the rights from the people working in the project, so also from the researcher, that it can comply with all its obligations under the grant. So that is a bit different, I think, from the US system. Now, joint ownership. Yes, our rules actually say that in certain cases there is jointly owned results. These cases are when participants have worked so closely together that either they cannot distinguish who exactly did what, who made which contribution. In that case, those results will be jointly owned by the participants involved. And a second time when there will be joint ownership according to the rules is that if, for the purpose of protecting the results, those results cannot be separated, i.e. the patent, there's only one patent, the results, so those will be jointly owned. As a rule, we have that the joint owners must conclude an agreement on how to allocate the ownership, who gets which share, and how to exercise that ownership, who is going to file for protection, how are the costs going to be divided, how it's going to be exploited, etc. So this they must do. They may decide not to continue with joint ownership, but, and this is new in Horizon 2020, it was not in the previous framework program, they may only do so once the results have been created. So not in advance, in the consortium agreement already said all joint results will be transferred to one participant. They cannot do that. They have to wait until the jointly owned results have been created, and only then can they transfer it to one owner or to a third party or whatever they want. This was done to protect weaker participants, to ensure that they don't sign away all the rights from the very beginning. So this is a bit the scheme. Is joint ownership easy to manage? Clearly not, and there's a lot of disputes about that, but okay, this is a fact of life.
Okay, I'd like to touch on this question of open innovation, because it's something that Commissioner Moedas, who was obviously here this morning speaking to us, something he often talks about. And a new feature in Horizon 2020 is a mandate for beneficiaries to publish scientific research articles under this open access model. Do you see a conflict between open innovation and protection of IPR, Gabriela?
You're asking the wrong person. I'm heading patent development, so obviously I see a conflict there. No, but I think it is critical, and here not just for my companies. I mean, I'd like to go a little bit back what we heard in the talks before. We need a strong system. Open innovation is just open. Just imagine you're an SME. You've invested in, worked together in this Horizon 2020 in projects, and then everything is published. And then it's not stopping the second this project is over. You have to invest to bring it to market. And then comes the third one, has not invested anything and can copy. I'm not sure that this is really beneficial. There should be room for open innovation, for sure. We should avoid trivial patents. I mean, now I will not put out all these things you have heard. There is also space and room for open things. Software, pure software, and so on should be there. But basic results, I think it's essential for Europe and companies all over the world to have a strong IPR right. If Europe would abandon it, the others will not.
Rick?
I don't see a real conflict. I think if things are managed well, really, these two concepts are really, in many ways, easily reconciled. First of all, the very concept of patenting is to reveal the invention. In fact, the word itself, the origins of patent as a word was the revealing of the invention. So that's inherent in the patent system, and in exchange, you get a limited set of rights for a period of time. I won't use the word monopoly, because it's not even accurate. And that's the quid pro quo. So disclosure is part of patenting. And by the way, the U.S. now has moved to what we call first inventor to file, which is really first to file with a few little caveats. But there's pressure now to publish because, and of course, in everywhere else in the world, there's absolute novelty. So you want to file an application to avoid being undercut by someone else. in the same field, but there's nothing precluding you from publishing as soon as you have an application on file. And there are mechanisms for filing applications at lower cost. So I don't see a real problem. I do want to caution everyone, by the way, when you're talking about publications, just a little potential horror story. This is a classic situation where you have a publication that corresponds to a patent. The requirements to be an author are different from those to be an inventor. And I believe I saw that in the IPR Help Desk documents. And you should understand that. Now here's the problem. Typically you'll have 10, 15 names nowadays on the technical article, and you'll have 3 or 4 or 5 on the patent. So if there's a lawsuit based on the patent, a typical strategy is to go find one of the co-authors to see if that person made a contribution to the invention. Not to try necessarily to invalidate the patent for not having the right inventors listed, but to see if that person works for a different company and whether you can approach them for a license if you're on the defense, your client's being sued. And we've had several examples where this was successfully done. You get a license and the lawsuit's over.
Open innovation, open access, Raymond?
I think I'm inclined to agree with Rick that patents are a wonderful tool of open innovation. You mentioned that disclosure is a part of patenting. More than it's a part of patenting, it's a requirement of patenting. You're required to disclose, and as a matter of fact, if you withhold some of the disclosures, it can be a cause for invalidation of your patent. So there's a big requirement for disclosure. And what is really interesting as well is that when this patent system was set up hundreds of years ago, there was the trade-off between the disclosure requirement and also the benefit that you get from the temporary protection. What people haven't realized is that the balance has shifted totally on the disclosure part. That a disclosure in the past wasn't really a disclosure to the world. 150 years ago, if you wanted to read a patent, you had to get in your horse and cart, go into the local town, if they had a patent office, go through all the patents and search and see if you could find the thing. Even 20, 25 years ago, you had to pay a reasonable copying fee. You may have to pay somebody to read the patent for you. Nowadays, from the comfort of your home, even if your home is in the Seychelles, you can sit and log in and you can check every patent office in the world. The European Patent Office has spent tens of millions of euro on automatic translation systems, where you can take more than 50% of all of the patents in the Japanese Patent Office and you can read them in French, German, English, and other European languages in automatic translation. Now, it's not a perfect translation, it's a machine translation, but it's enough to give you an indication of which patents to look at, what is the state of art, and now you can build your next step in innovation based on the work that other people have done without having to duplicate, which is one of the real aims of open innovation. So the patents have provided this wonderful tool of enabling the open innovation to flourish globally.
Brian?
Yeah, it's because our mantra is patent before you publish. And for all the reasons that you've described, I think the other side of it is particularly around software, where you don't necessarily have patent protection. And I think a lot of this open innovation type of model and full publication and disclosure of key technical elements really stems from the software side of it rather than from the patent side of it, because there are so many other advantages to the patent system.
And Bart, I assume you don't see a conflict with open innovation.
I don't see a conflict in the sense that people have already said it, that you have the obligation to protect. This is also part of the grant agreement. So first you file for your patent, for example. If later you want to publish, yes, there is a requirement to publish in open access, but the decision to publish is already made. It's not a requirement that you have to publish, but if you publish, then you have to make it open access. But open access for publications, this really means that somebody can read it on the internet for free, either directly, gold open access, or after a certain period, allowing enough time for the publisher to recoup their costs, and then we call this green open access. So from that moment, you can read the journal or the article for free. We do have in Horizon 2020 a pilot project on open access to data. This goes much beyond. But this pilot is only for people who voluntarily think that their project fits the bill. And it's not all the data in a project that needs to be made open access. It is only certain data that they specify in their data management plan or data underlying certain scientific publications. So in this respect, the last one, open access to data, yes, this can have an effect if there was no protection of the data beforehand. Maybe one word about open innovation, which is for me still a very broad word. When I think about IP and open innovation, I think about access to the results, access to, including to IP. In this respect, generally our projects, they only have to give access, mandatory, of course they're free to give access to their own results, but mandatory, they have to give access in principle only to the participants in their own project. And only if the other participant needs access to background or to results of another participant, if he needs it to do his own work, or if he needs it to exploit his own results. This is a general rule in our project. There's one exception for affiliated entities, but only for those established in member states or associated countries. This brings the problem of the worldwide affiliates, the other ones. But in principle, it's basically a closed innovation access, from an access right perspective, a closed innovation system. We do have a few examples where we go beyond that. In particular, we have a number of public-private partnerships on the Horizon 2020. For example, in one of them, Future Internet, which is ICT related, we have access rights, not just for the project, but for different projects within this public-private partnership. So they will have to give access if another project needs it to implement their project or to use their results. And the only actual, at least at this point, system where we really go much further into open innovation is what we call the Innovative Medicines Initiative. So this is our public-private partnership. The aim is to speed up research for new medicines or new diagnostics. And there we have the requirement in the grant itself that participants must give access to any third party, wherever established in the world, but only for research use. So a third party can come to a participant and say, I want to use your result for research use, and research use is broadly defined, to see if this third party is not better placed to speed up the take-up of the results and to ultimately have a medicine becoming quickly on the market.
And has that worked well to date?
To date, I think it has been evaluated because now we're already in the second phase.
Yep.
And there has been impact assessment, so it has been positively developed. For me still, okay, we need to wait a bit more to see in the end if this system is better than the more closed system we have elsewhere. But it is indeed a more open innovation system that we have there.
So I thought that in Europe you had a research use exemption that was fairly flexible. Is that...
There is indeed a research use exemption. The only problem is that it's not interpreted similarly everywhere in Europe. And for instance, in some cases, economic use is excluded. So that is, in the grant we have, we may embed it and we incorporate all type of research use. Okay. It's very broadly. It's only when there is direct exploitation of the results, for instance, the diagnostic kit, if that is developed, you can use the diagnostic kit in your own research to see if it works, but you cannot directly commercialize the kit on the market. This would go too far, and for this you need the permission, a special license, and the participant is not obliged to give that license.
We don't have that in the US.
So
There's no research use exemption.
Okay. But you mentioned exploiting project results. Gabriela, Ericsson as a company, talk to us about the different ways in which Ericsson exploits project results to valorize IP, whether it's through licensing, assignment, joint venture, spin-off, franchising. Is there a preferred route that Ericsson as a company likes to follow?
Now, we are very strong in licensing our patents on the FRAND terms, and FRAND is a word that is created in the telecoms area, but I think even other areas we would exploit it too. So, I mean, it's licensing, it's not blocking, for sure, but this is what we take as a basis, that's what we do. Of course, there's joint ventures, but I also should do a disclaimer here. What I'm saying is my personal opinion. We haven't been so successful in our joint ventures, but cooperations with other companies, that's how it works. But typically, I would say licensing.
Okay, and Raymond, obviously this is your speciality as well. So how would you go about suggesting the best route to your clients and lead them down the path of licensing?
Well, even before you come to licensing, one of the things that came up was talking about joint research and funded research, and I heard the word trust being used. And a lot of universities are very nervous that what they have is going to be stolen by the big guys. They're afraid of a trust imbalance. And quite often they miss out on, there's a major fear also in the large companies who are collaborating with the universities. Because when the university is trying to commercialize an idea in collaboration with the university, the best way is to have trust and open sharing of information. The big companies, when they bring the information for open sharing, are very concerned about the fact that they're opening up the risks of their IP rights being transferred to the universities through these mechanisms. And that there is a fear of pre-existing inventions that have been made in the firms, or lateral inventions that are made in the firms being swept in. And when you're looking at something which is from a commercial level, looks interesting for university, it could be €100,000 or €1 million, but the companies are afraid that they're going to be putting 10 million or 100 million or €1 billion at risk in these collaborations. So there's also a fear on the sides of the companies that should be borne in mind, that when you're trying to establish trust, reducing that fear is a very important thing.
Okay. I'm going to come to the audience in a second, and yes, sir, I see your question there. Before I do, I'd like to touch on SMEs. As we know, SMEs are project partners in many Horizon 2020 bids. Imagine I'm an SME with limited time, money, human resources. I don't have the time or resources to think about defining, specifying, and agreeing on IP arrangements, let alone engaging a specialized IP legal firm to advise me. Do SMEs have any simple, cost-effective options to protect and valorize their IP? You might want the first shot at this one, Raymond.
Yeah, we talk to a lot of SMEs, and what we find is that, as a first level, very few SMEs are patent sophisticated. Mm-hmm. That most SMEs, they're struggling hard just to keep the business running, to bring in customers, to bring in investment, to develop their business and grow it. Only a very small number of SMEs even go out and patent in the first place. Less than 10% of SMEs have patents. The more sophisticated SMEs are looking at patents that are protecting their own technologies. They're protecting the core technologies, and stereotypically you want to make sure that if you have grown up in a garage, you want to make sure the garage next door doesn't copy what you're doing. If you're thinking a little bit ahead, you're thinking about, we don't want these Chinese companies to come in and take over our business also. But for most SMEs, the products that they make are not standalone products. They're products that go into another system. And when they're going into expansion, especially international expansion, it's the first time they get hit by the world of system patents. And when you're in the world of system patents, the patents for your core technology aren't the problem. It's the system patents that can stop you in your track. And very, very few SMEs have a strategy for dealing with that system issue.
Many of your clients SMEs, Rick?
They are, but I work primarily with life science clients, either biotechnology or chemical clients, where there's a clear need to patent that's well understood, even with smaller companies.
Okay.
I remember there was a sole inventor, a gentleman who came up through his own experimentation with a therapeutic invention, and he came to me right away to get a patent, because there's really not much you can do in life sciences or in therapeutics without some kind of patent protection. So for me, it's difficult to conceive, at least in my space, of taking that approach. So I would tell them, please get some advice of some kind quickly.
But if I can jump in on that as well, though, like for example, we see firms that are involved in diagnostics, and they will have patents in the core technology of the diagnostics, and then they want to spread to every doctor clinic to have this diagnostic unit in their clinic. When it comes to the doctors transmitting the data from this, they're going to be using Wi-Fi, they're going to be using the cloud, they're going to be using security systems. The patents that are in the diagnostics are not going to help them in that area. And this is the difficulty about it, that we cannot help a therapeutic company to get really good at the core patents in their diagnostics area. That's not our thing. But with the broad range of patents that we have in Wi-Fi and web and in cloud and in data analysis, all of those things come to play.
That's an excellent point, by the way. And I can tell you, I was very surprised about, it must have been 7, 8, 10 years ago, when I was visiting a client that was doing their field was biotech diagnostics. And I went to visit them. They only had about 20 employees. Fully half of them were computer programmers. And I was shocked, but you're really seeing a blending of technologies nowadays, particularly in this space, that's amazing and accelerating.
Brian, SMEs.
Yes, so from Imperial Innovations, we have a portfolio of spin-out companies, and a number of those companies have participated in fact, led Horizon 2020 projects, and they have been enormously powerful for taking a technology on from, as it were, there's proof of concept, there's an initial scale-up, and then there's that field trialing, taking it to a pre-production prototype. And Horizon 2020 projects have been very significant in that area. And I'm thinking actually of engineering businesses rather than necessarily healthcare ones. So a lot of the issues are much more self-contained.
How does Ericsson interact with SMEs in publicly funded projects, Gabriela?
Yeah, I mean, let me start also saying, I mean, SMEs is in a lot of countries, also in Europe, a very big basis. What did we hear before? London has 99.8% of SMEs. I was quite fascinated by the number. But SMEs, if you have patents, we would never, I mean, we never follow up with SMEs and ask them for licenses. It's always the big companies, simply because of the work around that. And so we are not taking them out of the market. But I think in such projects, what we clearly do, if a SME has an idea, we stimulate them filing this patent. But of course, it's a cost. It takes a lot of years. And even if they have the money to file, will they go all around the world? And then suddenly, in the other country comes this. So, I mean, we don't, of course, don't offer them the money, but we offer them every now and then some expertise in it. But it's tricky, and I think a system that stimulates even more SMEs to be able to protect would be very beneficial, but not avoiding them filing, because that has a big drawback. And for this help desk and other things, or financing in some extent, could be quite helpful. So the unitary patent is a little bit looking into how can SMEs get better financing, and I think my company and we are fully supporting that.
Okay. We had a question here in the middle, please. Microphone and other questions. Oh.
Thanks for very interesting views and food for thought, definitely. I come from a university, Søren Fransen Aarhus University, Denmark. And my question might be a little bit at the edge of what you've been discussing, but the issue of the optimal number of patents seen from a societal point of view and also from a university perspective, how many patents should we actually run for, as we do get cost when we run for the individual patents? Of course, there is the issues of the single technology patent possibility versus the more strategic pooling of a number of things that can be patented. So patent is, from my perspective, more an instrument than a goal, an instrument to further collaboration between industry and university, where the society interest is, of course, growth, jobs, ecosystems, and all that stuff. And with the unified European patent system, I think is in early 2017 it will start. does that imply that the optimal number, if we're having the optimal number of patents today from a societal point of view or university point of view, will the optimal number of patents be increasing in the future, given the costs are coming down? But basically, my question relates to societal interest as a goal, those goals versus patents just being instrument to furthering collaboration between industry
That's a very
and
interesting
university.
question. Can I group that with one other question from the audience? Is there, yes, second row, third row there, please.
Thank you. Raine Hermans from Tekes, Finland. I would like to refer to our previous pilot, which was based on kind of having a pool of technology owned by large companies. And could we combine somehow that pool and also talents from the universities, and so they could help SMEs to tackle their bottlenecks in their R&D processes, and so that could be a part of the story of open innovation, even regarding EIC.
Brian, I'm going to give you first shot at both of those.
So there's this balance between quality and quantity. And in our case, we file about 66 patents a year. And we are, and a lot of those are, well, we patent those because we believe there is commercial value to them. And so we do have a threshold of where we consider the commercial value to be. So we're not driven by the metric of just so many patents, and that's a good thing. They, for us, have got to have commercial value. We also take about 300 invention disclosures a year. So you can see there's a very significant cutting down towards that number of patents. And looking across the peer group of universities that we would look at, that sort of ratio is very similar. So without stating that there's necessarily an optimum position, that if you've got a very active group of academics who are coming forward with inventions, and that part of the ecosystem is working well, I suspect that you would get that sort of attrition rate from invention down to number of patents. I think just turning to the other question of the pooling of patents, and I will leave you to discuss the subject of pooling of patents, but when your starting point is a piece of research from a university, you start to build a business proposition around that idea. And it's often, well, I think it's very difficult to find something else that's going to match that appropriately, because all business ideas are organic. They develop in their own particular way, and that to try and force fit some other intellectual property in, I think, is difficult, even if you were looking at the intellectual property at that initial stage. Because we've heard a lot about people advocating being champions for their businesses. When they become champions of their own business, they become very determined about their particular intellectual property position.
Pooling of patents, Raymond.
I can answer both questions from our perspective. First of all, I'm originally an engineer, and it's very appealing to be able to reduce something to a single number. But it's impossible to say what is an optimal level of patents. What I can say is that if you are trying to license out patents, and if you're in discussions, just having one patent is very exposed, because there are two defenses. One, people will say that we're not infringing, we're not practicing your patent, or the other thing is they may even challenge the patent, and they may challenge the validity of your patent. If you have a single asset, it's an all or nothing thing, and you can be very exposed and you reduce your chances of success. We believe in the power of portfolio effects, that the more patents that you bring to play in this, that the more you can bring in value, but also the level of risk can be reduced. Our firm has got 40,000 patents, and if you're asking me, is this enough, I can tell you we have a team that's actively out there trying to buy more patents right now. So we think even 40,000 is not enough. So that answer probably might frighten some people on the numbers. When you come to the question of pools, also, concentrating the pools in the hands of an industry player has some disadvantages. We talk about universities trying to commercialize. I know one of the objectives of inventors is to make money from their intellectual property, but it's not the only objective. Sometimes people want to have patents, they want to have intellectual property out in the market for prestige, but another reason could be that they want the world to benefit from it. I was talking to a medical researcher who he had identified a cure for cancer, not a cure for cancer, a detection for cancer, that he didn't want to sell it to one of the pharmaceutical companies because he was afraid that that company would buy that patent from him to make sure their competitors couldn't practice it. And they mightn't even practice it themselves. And as far as he was concerned, he wanted as many people as possible to benefit from that patent. Now, we don't work directly in the area of pharmaceutical patents, but in the patents that we acquire, we are motivated to license them out on a non-exclusive basis. So we want everybody in the world to benefit from the intellectual property. So getting the hands of patents into a company like ours, who is motivated to license the world, means that you increase the potential for commercialization of it, so return to the inventor, but also you increase the dissemination of the patent to the world may benefit from it. And if you're in a business where you want to have more adoption of this technology, it can encourage adoption of the technology so that you can then generate more in business. For example, fax machines. If only one person had a fax machine, it's no good having a fax machine. You want to make sure as many people in the world have fax machines so you can send and receive faxes. So it's the same with technology. If you can encourage more adoption of the technology, you can then go and sell more technology to those people that you've developed this adoption.
Okay. Brief comment from Rick and Gabriele, and then we'll give the final word to Bart. Rick.
Well, that's a tricky question to fully understand because, you know, there are patents and then there are patents. I mean, there are patents that are 2 pages long. There are patents that are 300, 400, 500 pages long. Then numbers by themselves I don't think mean much necessarily. You could have a patent that is split by the patent office, in the US at least, into 5 or 10 or 15 patents. The applicant themselves can split their own patents or file follow-on patents called continuations, and you could have a family of, there's no limit, basically, and they all will have, in this case, in a particular family, they'll have the same disclosure. So it's essentially the same content other than the claims, which map out the legal boundaries. So if you're talking about how many patents are enough for a company to own, is that the question, or how many patents are enough for the world to benefit? If that's the question, then bear in mind, patents have a limited lifespan. Once they expire, they're in the public domain. So in some sense, the more the better.
My point was there are costs to taking the patents. So given that the costs are driven down, we should increase. I'm not interested in optimal number.
Right.
But more that now the surroundings are changing. And actually my concern is much more the collaboration that creates value to society than the patent itself. And
So-
if the university do not choose to take the patent, we give it back to the researcher. So from a university management point of view, there are costs of keeping this business up. And what we are really interested in from a management point of view is having the collaboration with industry, much more the patent as such, because we are not in business for earning money. We're in business for students and basic research and applied research and getting it out there. Money is for business. That's my point.
We could have a completely different discussion on this.
I'll just say from that perspective, that's a case-by-case decision you have to make, it seems. That weighing the value of the patent versus the other considerations. So that would be my answer.
Okay.
I actually thank you for the question, because with that I'm able to give this comment here. I think there's too many patents filed. It's going up, 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 up. And we heard before China is now the biggest filer. How many of these cases are ever seeing US or Europe? Not much. I mean, clearly there's good inventions there. But if you look, it's a tendency, you always have to more. But quality is essential. I am really a fan of quality. What's the perfect number? If you have a good invention, it should be filed, but not every tiny small detail just to have saying I'm the big guy here, I have 100 more. So we have 39,000. Bad luck, I'm 1,000 behind you, but I don't mind. I mean, I don't mind, as long as I could say, okay, we've covered our R&D and it's enough. Clearly, you have to have a certain number. You cannot go with one. But we're a little bit too much in the number race here. The unitary patent, that was part of your question, if it brings more, I think it's time to have it, specifically looking at the US market where it's unitary. I'm not sure if it's going to be so much more filings. I don't think so, because it is still a cost adjacent to it. But I think what it should really do is that SMEs could be able to file for okay money in a lot of countries. But big companies like ours, for us, not a big difference, and we're not going to file more because of that.
Okay. Coffee is waiting, but we did start 5 minutes late, so I'd like to give Bart the final word. Bart, this feedback, is this helpful, useful for the European IPR help desk?
Well, no, it's clearly interesting feedback. Just on the cost of patent, I just want to mention that money of the grant can be used to protect the results. And we want, of course, only those results which are commercially valuable to be protected, not just any result protected. And the protection needs to be adequate. It doesn't mean always to file a patent. It can be a different way of protection. But I'll definitely take some of the comments with me, and we'll see what I can do.
Very, very good. Well, please join me in thanking the panelists for an interesting debate.